Fershtman, and she is widely recognized as one of the nation's leading equine law practitioners. Her law practice crosses all equine breeds and disciplines. She handles a wide variety of disputes frequently encountered in the industry, including business disputes, personal injury, sales disputes, and others. She also drafts contracts to help people avoid disputes. She is one of less than 15 lawyers nationwide and the only one from Michigan to be named a Fellow of the American College of Equine Attorneys. Julie has successfully tried horse-related cases before juries in 4 states. She has written over 200 articles on equine law and 3 books, Equine Law Enforcement, More Equine Law Enforcement, and Litigating Animal Law Disputes, a complete guide for lawyers. The 3rd book that she co-authored was published by the ABA. She is president of the 41,500 member State Bar of Michigan for 2011-2012, and she graduated from Emory College in 1983 and Emory Law School in 1986. And in case you didn't catch it, I'm really proud that she's from Michigan.
All right, why don't I get started? If the other locations have finished your introductions, great. Otherwise, I'm plowing in. I'm hoping that everybody here has the written materials that are designed to accompany today's presentation. Some of you have seen PowerPoints. I don't have that. I was told it wasn't needed. So from all of the locations, I'm hoping you have them too, them being the written materials. And as you'll see in the table of contents, there's a lot to be covered in the short time that I have here. And I'll start by talking about the Equine Activity Liability Acts. Great discussion to have right after a big lunch. I will avoid gory details of the lawsuits that have been filed nationwide, the lawsuits that I've handled that are equally gory. I'll move on to a discussion of negligence because that is relevant in the states that have no laws, although everybody who's participating today is in a state with an equine liability law. But negligence liability, as you'll learn, is applicable. It applies when you're not necessarily dealing with an injured person. It may apply in not only states that have no law, and there are 4, but when you're dealing with an injured horse or something that doesn't trigger the equine liability laws. So it really kind of is relevant. I'll move on to avoiding liability and strategies that I recommend that could be useful and hopefully effective in keeping lawsuits and lawyers away from you. But then I've been told to talk about contracts. So with the time I have, there's one contract I'd like to spend a lot of time on, and that's a release, also known as a waiver of liability. I'll spend the bulk of my time in the contract area about releases. Why? Because people tend to ask me a lot of questions about waivers and releases of liability. So expect that there will be a lot of discussion on that. I'll talk about a few other contracts in the horse industry, and then there will be about 15 minutes for questions, and I will do my best to get as many questions from all of the locations answered. So, 45 minutes of discussion, lots to cover. Let me get started by talking about the equine activity liability laws. What we know right now, today, Saturday, February 25th, is that nationwide 46 states have one of these laws. Which ones don't? Nobody on this call is in those states. The state of New York and California, Maryland, and Nevada do not presently have a law on the books. Anybody you know in those states doesn't have to worry about the equine liability laws. But one thing that I'd like to share with all of you, because everybody in this group, including the people at the different locations, have to deal with these laws, is that they all differ. Every single one of the equine liability laws differs in numerous different ways. And let me break it down for you. You will see in the materials that I have given you links to the different state laws. Let me share a little bit about each one for just a couple of minutes. First, let's talk about Iowa. Yes, I'm in Michigan, and the Michigan people feel they're getting shortchanged. Don't worry, we'll get to you. What do you need to know about your law in Iowa? A couple of quick things, and then we'll talk about common characteristics. Our Iowa friends here should know their law was amended last year to involve not just equine activities like the other states do, but to broaden it to include a variety of different animals, to include swine, sheep, goats, llamas, donkeys, and a variety of other animals. So your law is not just an equine liability law, your law is an animal activity liability law. In fact, it refers to domesticated animal activities in your state. Take a look at my materials, Iowa people. because you'll see that the contract language requirements in your state are extremely unique. You don't just have to put in your contracts the usual warning language, rather there's much, much more. Take a look, Iowa people, you'll see the differences. Michigan, what do we need to know about our Michigan law? I'm going to look up at our Michigan folks who have made the effort to come here today. In my honest opinion, as an attorney who's practiced for 26 years, mainly in the equine arena, so to speak, Michigan has one of the worst equine liability laws in the entire United States. Why? You'll learn as I explain the common characteristics. Michigan's law has been tested. The Michigan Supreme Court just a couple of years ago issued a case reaffirming what I've been saying for years. We have one of the worst laws in the country. But fear not. You have the ability, Michigan people, to help reform and tighten up our law, because there's a bill pending in the Senate right now, Senate Bill 738. You may want to make a note of it. This bill takes the weakness in our law that you'll learn about and tries to overcome it, and it tries to eliminate it, to give our law some teeth so that we can actually get some liability limitation benefits, more than we currently have. So I caution you about that in Michigan. You'll learn a little bit more about the weakness later. Nebraska people, your law was amended, I show about 10 years ago, but it was amended in regard to the sign requirement and the language that goes into it. And it requires in the state of Nebraska that equine professionals post warning signs. And it says that your contracts, if you are an equine professional, need to include the warning language that appears on the sign. In the materials that I wrote, Nebraska people, I put the warning language there. But I'm encouraging you now, I encourage you to take a look at your law, which I've linked you to, and go to the different sequences of the law, because the language that I've given you actually was amended just a slight amount. You could use the language I've given you and probably be fine, but Nebraska people, please note, there have been some changes to your law. Interestingly too, Nebraska, just like Michigan, you've got a sign posting requirement that requires in Nebraska that the letters be black and that the lettering for the word warning on the sign be 3 inches, the rest of it be 1 inch. What do I think of that? I think that anybody who makes signs in the state of Nebraska is going to be in business for a long time because of the sign requirement in your law and the lettering size requirement in your law. Michigan, you only need 1-inch letters on the language that goes in your sign. And that language requirement, that sign posting requirement, is only for equine professionals. Average horse owners, people who do trail riding just for fun, who don't breed or train horses, don't give lessons, don't board, you don't have to worry in Michigan about the sign posting requirement. Probably too for Nebraska. It's only a professional issue. Now we get to our friends in the state of Minnesota who've been very, very patient. And they're curious. They're all wondering, well, what about our law? Well, I'm sorry to tell you, Minnesota, your law is in a league of its own. Why? Because the liability limitations under the Minnesota law don't apply except to nonprofit entities. Very unique. That is the only group that benefits from the law by its own terms. But it does say if you donate services, goods, maybe even animals to a livestock or to a nonprofit involved in an equine activity in Nebraska, in Minnesota, you can benefit. So Minnesota, again, your law really is in a total league of its own. Maybe one day, if you choose, your law could be broadened to resemble the laws in the other states. But for now, Minnesota, you may need to sit back and listen to some of the discussion, because many of the things that we're talking about may or may not apply to you. So what do these equine liability laws do? What's so great about them? What's so good about them, really, is these laws say that if you are a participant in an equine activity, you can't make a claim against an equine activity professional, equine activity sponsor, or another person, and another person could be another participant, if you are injured or worse while you are engaged in an equine activity. All of these terms, engaged in an equine activity, participant, and the fact that you can't sue a professional, sponsor, or other person, these are usually defined in the law. So you've got to take a look at your law and figure out, am I a participant? Is the person I want to sue a professional, or am I a professional who could benefit from this law, or am I a sponsor? You need to look at the law to see if you benefit. Chances are you very well could. It sounds pretty good as to what I'm telling you so far. It sounds pretty good because you're hearing that the laws could protect you and keep you from getting sued. Here's the bad news. in just about every single state with an equine liability law, there are exceptions. And I'd like to spend a few minutes talking about these exceptions in the law. This is where your lawsuits will come from. But don't worry, I'm going to try to bring these exceptions to a state-by-state level, because I know we've got 4 states on this. The first exception that appears in most of these equine liability laws, this comes into play in all of the state equine liability laws, is that you could be liable. You could find yourself with a claim or a suit against you if you provide faulty tack or equipment that you knew or you should have known was faulty, and that fault, that problem with the equipment, was the cause of injury, death, or damage. What does that mean? It means that if you supply a horse with a bad, maybe a faulty or a defective headstall that breaks during the ride, that's a faulty equipment issue. It means that if your cinch or girth is breaking apart, not necessarily loosely connected, we'll leave that as a non-issue for now, but if there's a problem with the girth, the cinch on your saddle, and it breaks, or the billet that connects the girth to the saddle, that is a faulty tack or equipment issue. This has been a litigation issue around the country. People have raised it because sometimes the injury, people say, is related to the equipment. This exception, I think I mentioned, comes into play in every single state participating today. Iowa, Nebraska, Minnesota for nonprofits, and Michigan. That, we then know, is a potential ground for a lawsuit against anybody here in this conference. Let's get to the second. I'm going to share with you 6 common exceptions, and here's the second one. This is really only relevant for the folks in Nebraska, Minnesota, and Michigan. If you provide an equine to somebody else, and you fail to make reasonable and prudent efforts to determine the ability of the participant to safely manage the equine, then you could be liable. I call that, when it really comes down to it, because it's kind of long-winded, I call it the mismatched horse and rider claim. That seems to be the essence of it. That has been the basis for lawsuits all over. In fact, that is what most of the lawsuits around the country tend to involve. A claim that you provided a horse to somebody else to ride, handle, work with, drive, and you should have known that this animal had a problem. And you failed to make reasonable and prudent efforts to determine that this person handling it, riding it, working with it, could manage that horse. This is where people sue. What does that mean? I guess it means know your animals and ask a lot of questions to people who are about to ride, handle, or work with your horse. Let's get to the third exception. And which one? Well, let me tell you the exception, and I'll tell you that this does apply to all the states. This exception applies if you own, lease, rent, or are in lawful possession of land or facilities with a dangerous, latent condition. Own, lease, rent, or are in lawful possession of land or facilities with a dangerous, latent condition. What's a latent condition? That's a condition of the land that you just can't see. If somebody is injured from that and you fail to put up a noticeable warning sign to tell people about that dangerous latent condition, not just the warning sign that says warning under the equine liability law and equine professionals not liable. I mean a warning sign that says gaping hole covered with leaves, or a warning sign that says live wires in area. That would be the type of warning sign that the law expects you to put up. And if you don't put up that type of a warning sign and you have a dangerous, non-obvious condition where people are riding, working with, or handling horses or driving, well, you could be liable. Has that exception come up? Yes, it has. It comes up occasionally in cases where people are injured. They claim that something that wasn't visible was known to the provider and the owner of the land, and whoever kept that premises or was responsible for it didn't warn the participant. Very sad case involving AT&T under that exception. It's a terrible, tragic case of trail riders with a trench right across the area where people were riding. A horse tripped and killed a rider. The liability issue was that very exception. Not a lot of cases compared to the others, though, under that exception. So that's the third. Let's get to the fourth. Some of the laws, Nebraska and Minnesota, will say that an exception to the benefits of these equine liability laws is if the person who provided the horse, owned the property, engaged in willful and wanton disregard for the participant and the safety of the participant. Michigan, I told you about Senate Bill 738. That is the exception that I'm hoping to put into Senate Bill 738 to protect us from liability and kill an exception that I'll share with you as number 6. So the fourth exception is willful and wanton disregard for the participant's safety. That's a pretty tough standard, lawyers would say, because willful and wanton disregard is almost to the point of setting out to cause somebody to be injured. Fifth exception. The fifth exception that I see around the country, and that Iowa and Nebraska both have, is you cannot benefit from the liability limitations if you engaged in an intentional injury to the participant or a reckless act. I think that makes sense. When somebody sets out intentionally to cause an injury to a person, I don't think it's fair for any liability law to say, you get a pass. We won't let you get sued. So that is an exception that I see in those states. Here's the sixth exception, and this is the one that I truly believe makes Michigan's law so weak. But actually, in looking at these laws, Minnesota may have this exception too, and Nebraska may have this exception too. What is this exception? The exception is the exception of negligence, a negligent act or omission on part of the equine industry professional, equine activity sponsor, or another person. And people sitting here today might say, well, so what? These laws shouldn't prevent liability for negligence. Yes, they can. Yes, these laws can prevent liability for negligence. That's the point of these laws. Michigan, long story about how we have this in our law. But the negligence exception played out in litigation and in claims means that a person who was hurt because your horse threw them, your horse bit them, knocked them over, whatever, a person who was hurt would say, well, you failed to act as a reasonable person would act. I'll tell you the definition of negligence, and it's in your materials, actually, if you'd like to take a look at it, and that would be on page 3 of the materials. We'll get to that in just a second. Before I leave equine liability laws and try to stay on schedule here, a couple of things I want you to know about these laws that I touched on briefly. In several of the states with equine liability laws, there are signposting requirements. All 4 states today have these signposting and contract language requirements. And be careful, because in some states, and I haven't been able to determine, I think Minnesota is one of them, but I'm not able to determine how many states are clear on this. If you are required to post a warning sign and you don't, some of the laws around the United States, typically in the southeastern part of the United States, are very clear that you may lose all liability limitations in the laws. Minnesota's law, interestingly, says one of the exceptions that could cause a person to sue could be based on the fact that you didn't post the warning sign. Sure, the person has to be hurt too, but they could raise it as an issue. The bottom line, my advice before I move on, take a careful look at the equine liability law in the states where you live, and if you do business in a number of states, look at the laws in the states where you do business, and make sure that you comply with the signposting requirements if they apply to you, and the contract requirements if they apply to you as well. I know I would normally have questions right now. Hold the questions, because I'd like to move on right now to waivers and releases of liability. It's been discussed around the country whether a waiver or release of liability can release a person from liability under an Equine Activity Liability Act. I'll take the position for today's discussion that you can and that you should use a waiver or release of liability. So let's take a look, if you can, at page 2 of my materials. Actually, you know what? I skipped negligence, so let's go to page 3, and then we'll get to waivers in a moment. I mentioned to you that the equine liability laws apply where a person is injured, a participant in an equine activity is injured. But what if you're dealing with a claim that doesn't involve an injured participant? What if you have a claim or even a suit where the equine liability law simply is not at issue? It doesn't apply. Then you'd be looking at the standard, which is on page 3 of my materials at the top, of negligence. This is the exception in the states that I referred to that also creates problems with equine liability laws. What is negligence? Well, the bottom line of negligence, and the definition is in your materials, is if a person claims you were negligent, and I'll give you examples to flesh this out a little bit, their argument against you would be that you neglected, you failed to act as a reasonable and prudent person would act under normal circumstances. It goes on a little further, you'll see the definition. You'll probably scratch your head and wonder, what the heck is this about? What are people sued for under a theory of negligence? Let me give you some examples. In representing people around the country in horse cases, I know that negligence cases have come out when a person claims that the boarding stable wrongly or negligently pastured a dressage gelding in a group pasture, put the gelding in a group, and the owner said that was negligence. Why? Because the owner said a reasonable stable would put my dressage show horse in an individual pasture where he wouldn't be kicked. There was no contract covering it, so the owner of the horse sued for negligence. Another example, another boarding stable example. Horse got loose in the middle of the night because somebody either broke in and opened up the door of the stall and let the horse run loose, or because the barn door simply, or the stall door, was not manufactured and maintained properly. We have a racehorse then that got out on the road in the middle of the night, was killed by a motorist, actually killed a motorist too, but the owner of the racehorse said to the stable, "You are negligent. You're negligent because a reasonable stable would make inspections of its stall to make sure that the stall doors were secure and that this horse would not get out in the middle of the night." Reasonable horse owners do inspections, they say, and would not allow these things to happen. These are examples of negligence claims in action. I've worked on a few cases in California. Negligence claims have played out there as well. A case I worked on, we actually won in the California Court of Appeals. I was a behind-the-scenes attorney on that. Involved two friends going out on a wonderful trail ride, beautiful day in California, until something happened. This Tennessee walking gelding, which was a beautiful, steady, very well-trained trail horse, somehow spooked and went down a very steep hill. The rider lost control and tumbled off and became a quadriplegic instantly. That quadriplegic rider brought a lawsuit against the owners of the horse. It wasn't the owners who were even present on the day that this ride occurred. There was somebody who was permitted to use the Tennessee Walker, but she sued the owners anyway. "You're negligent," she said, because a reasonable horse owner of a Tennessee Walker, well-trained, would make sure that only the proper people are given the right to use the horse and take others for a ride. "You then," she said, "did not act as reasonable people because the person," she said, "who joined me on my ride and let me ride this horse really didn't look out for my safety. Took me in an area that wasn't safe, made the horse go too quickly, you got the rest of it." All of this is under a general theory of negligence. And all of this, under these negligence claims, boils down to this. A claim against you under negligence would be a claim that says you didn't act reasonably, or you didn't do what reasonable people should do. What does that mean then? Anybody could look at anything that we do day in, day out with our horses and say, well, I know better, and what you're doing isn't reasonable. Negligence then is a standard that is loaded with trouble, because it's often up for discussion and dispute as to what a reasonable person does and doesn't do. And the other problem I find as a practicing attorney for 26 years, expert people are out there in this industry making a living, looking at all of us on this conference and even sitting here with me today and saying, I know better and they did not act reasonably. Negligence is a very difficult standard to deal with. In my opinion, that's why equine liability laws should avoid it, should get rid of that standard, and should define what is and isn't liability. That's what Michigan people should know about Senate Bill 738. We're going to get rid, if it passes, of the negligence exception. Let me now move on to avoiding liability for just a couple of minutes. Liability releases that I'll be talking about would be a very powerful way to avoid it. But I say in my materials on page 3, understand liability. Everywhere I go, people tell me, Julie, I don't need you as an attorney because we have a zero liability law in my state. Where in the world did they get that idea from? None of these laws is one. Understand it. You don't have to know as much as an attorney knows. Have a general idea. Come to programs like this all over the country as they're offered today. Read as much as you can about laws and liability that apply to horse people. There is information out there. I write it. I have a blog, and there's plenty of information put out by My Horse University. Number 2, safety program. If you have a regularly implemented, reasonably well-followed safety program designed to protect people and to avoid liability, well, who knows? That may avoid problems. How do you do it? I offer 2 examples. You now heard that many of these equine liability laws allow liability for faulty equipment. That means then to inspect your equipment, especially Western riders, those Chicago screws. Check those before you bridle up a horse for someone else to ride. Train your workers. I'm sure that there are people here or in the other states that have employees. You are business people. If they don't share your dedication to safety and they make a mistake, you, the employer, by law, will bear that responsibility. Make sure they share your dedication to safety. Train them as well as you can. Moving on to third, on page 4, third suggestion, use releases, liability releases carefully. Make sure that they're well worded. People are going online and sharing forms that they've received without even knowing if those forms are legal in their state. Please don't fall into that problem. Use releases, but make sure that they comply with your state law. The states differ tremendously on that. Liability insurance was number 4. You had a presentation on insurance. I understand there were many questions. I'm ready to take some of those questions, time permitting, because I work a lot with liability insurance in the work that I do, and I work with a lot of the equine insurance companies every day. 5th is read your equine liability law. You now will have links to them. You can find them after today. 6th is sign posting. If you're required to post the signs, typically it's the professionals that have that requirement. Make sure that you have the sign posted and that it complies with your state law. And caution, I've worked on a couple of cases around the country. Somebody is selling an Equine Liability Act sign that looks like a one-size-fits-all sign that doesn't comply with any state law. Somebody's making a lot of money with that sign. Make sure that the sign you buy, if you choose to buy one, is really the sign that you're required to post. How do you know that? Read your law. Your law will tell you who posts it, what color it has to be, how large it has to be. Pennsylvania's sign has to be 2 feet by 3 feet. That's a big sign. But read your law for the sign posting. Number 7, contract language. Usually the same people who have to post warning signs are obligated under their equine liability laws to include language in your contracts. I warned you, Iowa people, that whatever goes in your warning sign is not what necessarily goes in your contracts. There's more, and it's in the materials that I have here. Number 8, consider whether you want to set up a corporation. Some people think it's a great thing, some people don't. Consider it, learn about it, decide if it's right for you. I'm going to zip at this moment now, and it's in my materials at page 5, to contracts. And the number 1 contract that I strongly recommend for all of you to consider very carefully, liability releases. I'm sick of people telling me that liability releases are not worth the paper on which they're printed. I hear it all the time. I even hear it from lawyers. But I'm here to tell you, with a little bit of time that I have, why liability releases fail. It's not in the materials. We'll get to some of the details in just a moment. The first reason they fail, out of the 3, is that there are some states around the country. None of the states in today's conference are those states, but there are some states that simply don't enforce them. That would be New York. There's a General Obligations Law 5326 that invalidates releases in certain settings. Montana hates liability releases. Virginia has a Supreme Court opinion that says we don't like them. There seems to be something in the Louisiana laws that doesn't like releases either. But that doesn't apply to all of us. So we don't have to worry about the first reason why they fail. Here's the second reason and the biggest reason: faulty drafting. Faulty drafting of a liability release. What do I mean? It's the same people who think they're not worth the paper that they're written on that don't take their releases seriously. They will find a form, they'll get something from years ago that is not current. Examples of faulty drafting: there was a case in the state of Ohio back in 1994 where the document was taken from a form, I don't know where they got it, and instead of having the usual release language that says, I, the signer, agree to release and hold harmless whatever you for your own liability or negligence, all this said was, if I get hurt, I will hold you harmless and release you if I am hurt. That's not a release. That lawyers would call an indemnification agreement. So the lawsuit comes in because the one who signed this thing sued. And the court said, we're really sorry. We in Ohio will enforce a release, but that's not a release. Faulty drafting killed that document. Other examples that I see more often than I care to will be when somebody has a business. We talked about maybe thinking about incorporating if you're a business person. What if you do? but your release doesn't say that the person is releasing your corporation. That's faulty drafting, because when that lawsuit comes in and the business isn't named as being protected and released, you've got a problem there. That's another example of faulty drafting. The third reason why releases fail is that there's a fault not in the way it's written, but a fault in the way the document was presented and signed. Something wrong with the way the release was presented and signed. What do I mean by that? Some people who don't know any better will ask a child under the age of 18 to sign contracts, including releases. You can't do that. Children don't have the legal capacity to sign contracts except for the necessities of life. They may think horses are, we may think they are, but the law doesn't view it that way. Those documents are invalid from the get-go. But then the next question that I know you're thinking, well, what if a parent signs the release on behalf of the minor child? Courts cannot quite make up their mind all over the country. Some states have said that a parent can legally sign off for the child. Others are just not sure. Our Michigan courts looked at this issue a couple of years ago and said, we're sorry, but a parent cannot sign off a child's right to sue. That means that you may, as a business provider, want to include a release that says, I, the parent, am signing for myself and my child, but then have a little clause at the end that says if any part of this document is invalid under existing law, it will not invalidate the rest of it. That becomes important if you have a lawsuit involving an injured child and your release doesn't look so good because it doesn't comply with state law, and all you have to do, or your lawyer will do, is say, we'll just X out that little provision and take the benefit from the rest of it. But that's a defect in many states. More states say that parents cannot legally sign off on a child's right to sue, and there still are some that say, yes, it's legal. When in doubt, find out your law and proceed accordingly, and draft your documents accordingly. So let's talk about releases. What makes these documents work, and what are the common characteristics of good releases? Well, I've got that covered on page 5. Number 1, and I'm giving you some general suggestions, obviously not legal advice, make sure it's readable. I see people who think they're really clever finding language that lawyers like me used to use in the 80s that say heretofore, wherefore, the said, whatever. Make it readable and plain English. That is the way contracts are drafted in modern times now. So make sure it's understandable and readable. You want to make sure this is a document because it has so much power, potentially, that people can understand. Getting to the second thing, title. Personally, I don't like a document that is not called a release of liability, but has a release tucked into it. For example, a boarding contract that says boarding contract at the top. But in the body of it, there's a release. I rather would see stables who board have a separate release of liability for all people entering the premises to sign. And that document would be entitled Agreement and Release of Liability, or Release of Liability, Waiver of Liability. Make it clear what this person is signing, so they don't claim that they were tricked into signing it. They didn't know that this document included a release. Number 3, bottom of page 5 of my written materials. Specify who is being released. I touched upon that a little while ago, and I see that quite a bit in litigation. States are not always willing to rewrite releases to protect people who are not described in the document or named in the document. And you may be thinking, wait a minute, I own Morningstar Farms, you may be thinking, and I have managers, but they just come and go. I can't seem to keep good workers. And so do I have to change my releases every time a new manager comes or goes? Not necessarily. Under the law of most states, it's enough if you have Morningstar Farms, Inc., and it's officers, directors, employees, agents, managers, whatever. Morningstar Farms, LLC, it's managers, members, employees, agents, and you can name people if you would like. Going on to page 6, who's signing it? Wouldn't hurt to get details on the name of the person who's signing it, and make sure that the person is signing it for others, that they're signing it for themselves and for others. I actually litigated this years ago in the state of Florida. A mother signed a release of liability when the son was taking lessons. He discovered girls and stopped riding horses, but the mother decided, because her son was so busy doing other things, I want to start riding horses. I want to take lessons. The stable thought it was fine because there was a release on file. What it didn't realize, that release that the mother signed was very clearly signed not for herself, but on behalf of her minor child. So when she got hurt, broke her arm, and sued, the document was of no validity. Make sure the document is clear, that the person who is signing it identifies themselves and tells you they're signing for themselves and or for others, and identify who the other people are. Number 5 in my list, risks. Sure can't hurt if a person's agreeing to waive and release liability that they have an idea of what they're getting into. I don't mind a document that scares people with risks. The risk of people falling, getting hurt, injured, the injuries that come from horses kicking, bucking, rearing, throwing people, spooking, running away from danger by trotting or galloping, backing up quickly. You may think if you put that in your document, you're going to scare them away from taking part in anything you do. Why the heck not? Well, why not scare them? Let them know what they're getting into. Only then, it would seem, would their release make sense. They're releasing you once they know what they're getting into. Put the risks in. And even a little bit further than that, your equine liability law in just about all the states will list inherent risks of equine activities. Nobody says you have to include those inherent risks unless you're maybe in the state of Iowa or in the state of Ohio. But you could take the list of inherent risks and put that in your document too. Then throw in a few more. Doesn't hurt. Number 6, on page 6, I talk about the Equine Liability Act warning language, and I actually give you that language. Looking at page 6, Iowa, take a look. I give you the language that domesticated animal professionals need to use. Michigan, I've given you the language that equine activity professionals need to use. And then I go on to Nebraska. And as I indicated, take a look at Nebraska's law. The last line actually was subject to a couple of modifications a few years ago. Minnesota, well, I don't think that there is any language requirement, but there is a posting requirement in the state of Minnesota about posting certain information in the equine liability law. With the time I have, I'd like to talk a little bit about contracts, because it looks like I've got about 5 minutes. The one contract I think that a lot of you will be utilizing or maybe signing if you're the customer is the boarding contract. A lot of horse facilities are boarding horses to make a little money, and a lot of people nowadays, because property is hard to come by, especially if we live in the city, are boarding horses. One example I give before I get to the boarding contract bullet points that you'll start to see on page 8 is this great example that's really kind of sad. Let's take the example of the customer of a boarding stable. He or she is going on this wonderful cruise for a long time, maybe a week or two, and leaves the horse at the boarding stable, but is not reachable. And the day after the customer leaves for vacation, Murphy's Law, the horse colics. The horse needs serious veterinary intervention. The stable calls the vet, and the veterinarian says, we've got to take this horse in for colic surgery. But you, the stable owner, are not sure if the owner will consent to that kind of expensive surgery. You, the stable owner, have no idea really what the owner wants. Maybe your contract doesn't even reference what to do in an emergency. You don't know. So you decide, well, surgery is going to cost about $4,000. Put the horse down, you tell the vet. And that is done. Owner comes back from the trip looking for their horse only to find out that weeks earlier or days earlier the horse was put down. But then it gets worse for the owner. The owner calls their equine insurance company to make a claim because the animal is no longer alive. And the insurance company, the equine insurance company that wrote a mortality policy says, we're sorry, but you didn't give us timely notice of this horse being put down. We couldn't investigate. We don't know what happened. We're not paying you anything. Now the owner has no horse, no insurance money, and is very angry at the stable. That will begin the discussion of the boarding contract because these are foreseeable problems, and I'd like all of you to avoid them, whether you're the owner of the horse or the boarding stable. Starting on the top of page 6, these are the minimum elements, I think, for a boarding contract. A description of the horse that's being boarded, and information regarding the owner, and emergency contact information if the owner can't be reached. Maybe I'll designate somebody who can make decisions on whether you can put my horse down or not. You'd want that information. Next is, in the next bullet point on page 8, information about the horse's health history. You're the boarding stable. Wouldn't it be helpful to know if the animal is current on inoculations, deworming, or even has some sort of a disease? You may want that information. The boarder, the customer, they may want to know that you're asking this too. It certainly would tell me that you're concerned about the health of all the animals in the facility. You can put that in the contract. Of course, the third bullet point is payment obligations. How much are your boarding fees? How much are your late payment fees? Is your late payment fee imposed on a monthly basis, weekly basis? Is it a percentage? Put that in the contract. A lot of boarding stables have been calling me in recent months, years actually, because of our horrible economy. They're not getting paid. And of course I tell them, well, I'm a 26-year practitioner. here's what I would charge to bring a lawsuit to collect this $800 that you are owed. My fee's going to be way more than that. Stables, maybe you want to put an attorney fee clause in your contracts that says if we have to bring litigation to enforce the contract, you pay our fees. Next bullet point, statewide programs, stable-wide programs for deworming and inoculation. That may be a good idea. Everybody gets it done at the same time and they consent to it, or you, the stable, will tell them on a board, get your vet out, time to put into the horse the 4-in-1 shot, 5-in-1 shot, Potomac horse fever shot if necessary or applicable, whatever. The stable can put that in the contract. Release of liability. I've seen a few stables that use releases of liability, like the type you learned about earlier today. But what about a release pertaining to the horse? A release that says even if you were negligent in the care and keeping of the horse, the owner agrees to release you. You can do it. And under the laws of most states, that is totally legal. Very few stables have put those types of clauses in your releases. As a boarding stable, do it. As a customer, understand that that clause can be very powerful. With the few minutes I have left, let me kind of wrap up boarding contracts. I talk about the final bullet point, how the contract can be terminated and the notice before termination. Usually it's a 30-day notice provision. Put it in the contract. But then there's another thing that I talked about that I would also recommend in all contracts, and that is if an emergency arises and the owner cannot be reached, they're in an area with no cell service, they can't take your call, they can't take a text, some sort of authorization given from the owner to the stable for the stable to somehow arrange for emergency veterinary attention. Or the stable might want to go a different way and say, owners, you need to make arrangements with the local veterinarian. If we can't reach you, we can call the vet, and the vet will know if you're willing to authorize expensive care. Make those arrangements, give them your credit card, and you get that taken care of first. But an emergency authorization is critical, and there are different types of ways that you can do that, beyond the scope of time, unfortunately, that I have in front of me today. Moving a little further in page 8, I talk about leases. The one recommendation I give, and you could see the bullet points in the materials here, recommendation I give, whether you are the one receiving the animal under a release, whether you are parting with the animal, under the lease, or parting with the animal under the lease, please get it in writing. My office has received so many phone calls from people who are parties to a verbal lease, and all sorts of crazy things happen. The one who's the recipient of the animal, we call the lessee, thinks it was given to them. The one who parted with the animal says, it was mine. They only had a limited use, or a, as we call in the horse industry, free lease, which is, you can have my animal, you take care of all the overhead and payment, don't pay me anything, just take care of it and give it back. Make sure lease agreements are in writing for a number of different reasons, if nothing else to avoid legal disputes and to avoid the problem that maybe this document, or this verbal agreement rather, is not enforceable. The document will hopefully avoid that. Sales contracts, bottom of page 8. I talk about the minimum elements for a sales contract. If you are selling on a regular basis, everybody on this participating in this conference, my suggestion to you, write a very well-documented, seller-oriented sale contract. Not merely a bill of sale. If you're selling horses and you want to avoid recourse from the buyer, you want to make sure the buyer gets the proper vet exam, but isn't coming after you if a problem occurs, you would want a disclaimer of warranties in your sale agreement. How do you do that? That varies all over the country. It varies state by state. Lawyers can help you find the language in your Uniform Commercial Code to make sure you have properly disclaimed warranties in your sales agreement. And remember too, the best sales contract in the world will not protect you from a claim of fraud. The law almost universally is a case against you for fraud will override that contract. So remember that when you use these contracts, it's not exactly a free pass. Lawsuits can still follow. The liability is there from the buyer seeking recourse against you. Well, we are now at that point where I wish I could go on with more cases and examples and ways to protect yourself, but I now have to go with questions. So I ask my people here, who you can't see, people here can, where do we go right now with questions?
Well, why don't we take one from the audience and then we'll take one off of our Facebook.
All right.
We'll just alternate back and forth with the time we have.
All right, I'm going to make the rounds. Anybody here in Michigan with a question?
Yes. How does the state of Michigan would be against a boarder who has abandoned the animal for over 30, 60, 90 days?
Excellent question. The question that was asked is, Michigan, under Michigan law, are there laws that involve or protect the stable? When you are boarding a horse belonging to somebody else, giving it care and keeping, and they just disappear and don't pay their board. There are laws, and I've written about this, and I think I have an article on my current blog, which is equinelawblog.com, on this. Every state differs in the rights of a stable when a boarder doesn't pay on time. Michigan has a stableman's lien law, which of course is also one of the worst in the United States. Sorry to give you the bad news, I didn't write it. The law was written in the 1800s. Michigan's law says, as an example, when you are given a horse for care and keeping, whether you're a boarding stable or a person like me, you have a lien automatically. Michigan says it's an automatic lien given to you, and that is really powerful because with that lien, given again automatically, there's no court proceeding, no documentation. With that lien, it says you can wait 8 months without payment, and just before you get to the 9th month without payment, which means you have to wait a long time for board to accumulate, you can have a sale of that animal. It has to be a sale done by a sheriff's deputy or a court officer. You have to write a letter at the end of the 8th month or at least a month before the sale. That letter is with language given to us in the law, and I can give you the citation later, or you can email me for the citation. Send the letter to that debtor. Let them know you've got a public sale plan. You have to hire a sheriff's deputy or court officer to conduct the sale on your property. And if you follow the law technically and properly, if you're the high bidder, for $10, $20, you own that animal. I have clients who have followed Michigan's law, and they've hired me to make sure they follow it to the letter, and they get a horse where board has been owed that could be rehabbed and reconditioned, and they've made money because they buy the horse at their own lien sale, they followed the law, nobody else showed up, bought the horse for $100, turned around on a debt that might have been $5,000 and sold the horse for $10,000 or $15,000 with careful care and attention. Follow the law carefully. Now, everybody else on this conference should be aware that the state laws all differ. In some states, you can't sell the horse until you get an order of the court. In some states, you don't even have a lien on the horse until you receive an order or permission from the court. In some states, you have to file certain documents. Take a look at your law very carefully. They truly differ. And make sure you follow it. Why? If you follow the law to the letter, almost every breed registry that I've worked with, and I've worked with the Standardbred, Morgan, Quarter Horse, Arabian, these registries, if you follow the law, will give you papers on that horse without even the signature of the last owner of record. If they're convinced you followed the law, you're going to get those papers. Now you can resell the horse, breed it, do whatever you want. And if you don't follow the law properly, you could be guilty of conversion, theft, whatever. You don't want that. You also don't want the buyer, when you didn't follow the law, to have a horse that was sold when you had no legal title. So make sure you follow every word in that law carefully, or hire a lawyer to walk you through it. Next state, where do we go?
This is from Minnesota. I am close to submitting the application for 501c3 tax status with IRS. Do you have any suggestions of how to best present this application for approval? What are some common errors that we should avoid?
This is a person who's going to be submitting for 501c3 tax status, nonprofit tax status, probably so that this person can receive donations that are tax deductible and derive certain tax benefits. I hate to tell you, but I'm not a tax lawyer, never have been in 26 years. So that question needs to be directed to a knowledgeable tax lawyer. My recommendation for that person is don't focus on an equine lawyer with a tax question. Go to a tax specialist, unless you happen to know an equine tax specialist. And there are two that I know in the state of California, very few on a national level. So I apologize on that one. Let's go with another.
What constitutes an acceptable level of proof when a seller attempted to determine a buyer's abilities, i.e. date, time, and questions asked, or paraphrase conversation, written or verbal?
This is a question that's not very clear, and it sounded almost like it was a liability question about the determinations they say that a seller needs to make of a buyer in regard to, I assume, the purchase of an animal, the use of an animal. Since I'm not quite clear of what it's requesting, and whoever submitted it can type over here a clarification, let me put this in an understanding that I think I have of the question. We talked earlier about the equine liability laws, and we talked about the fact that almost every state has some variant on this exception, that if you provide a horse and you fail to make reasonable and prudent efforts to determine the ability of the participant to safely manage the horse based on their representations of ability or whatever, you could be liable. I will assume that the question was asking, how can I make reasonable and prudent efforts to determine their ability to safely manage a horse? Whether this is a riding student and I'm an instructor, whether I am selling a horse and this is a would-be buyer, whether I'm taking a coworker, friend, whatever, out on a trail ride and putting them on my 23-year-old bomb-proof horse. How do I do that? I always recommend knowing your horse very well. If the animal has come to your facility, maybe you're a riding instructor and people are handing over horses for you to use, make sure you've tested it out very carefully. Know the horse, know how it operates, know if it's spooky, know if it has good vision, know what types of things will trigger bad behavior. If you are now asking questions of the rider, here are the questions you'd want to ask. What kind of riding lessons have you had before? Have you ever had a lesson before? How many years have you been riding? But don't just take that as an answer. Look at me. I haven't ridden a horse except for maybe once a year lately. I'm just too busy with my law practice and other involvements. If you asked me, hey Julie, how long have you been riding? I'd say, well, I'm over 50 and I've been riding since I was 8. Every year I ride. You'd say, wow, I'm going to put Julie on the most aggressive, dangerous horse because she can handle it. But what you forgot to ask is, in those rides every year, how often are you riding? And you'd hear me say, well, maybe once a year, and it's kind of a controlled ride, I don't get too crazy. Those follow-up questions are everything in your efforts to determine the ability of the participant to safely manage the horse. How often within that year, what have you been doing? Do you walk, trot, canter? And something that you may consider, riding instructors, anybody here who chooses to rent horses to the public, very few people do, maybe get a round pen. If you think you've made a good choice and a good match, see how this person rides in the round pen. Check out their posture. Are their toes down in the stirrups? Are their toes up in the stirrups? Make those determinations by watching carefully and then assessing. Next question.
How about a question from our audience?
Michigan. Yes. There's one back there, but one over here. Yes.
Well, I bought a horse, and it was through several different people, I guess, and so I never actually got a bill of sale. Is there anything how should I cover myself? Like, if my horse gets lost or something, how do I prove it?
That's a good question somebody posed, and that is, I have a horse, the sale was arranged through a variety of different people, and one thing I don't have is a bill of sale. And do you have registration papers on the horse? She doesn't even have those. Registration papers, by the way, are not the same as a bill of sale. Courts in a few states around the country, I'm going to digress for a moment because it's an important point, have looked at the question of whether registration papers really prove ownership. And the few courts that have looked at that have said, no, they don't. Because they know, or they've learned in this industry, that sometimes people will have a horse on the premises, but they don't record the papers. Or the husband and wife both own the animal, it's in the wife's name. People know too much in the legal system, apparently. Papers don't tell you anything. But this question was, I don't have a bill of sale. What can I do to prove that I own the animal? Well, let me get to another question for you. How long have you had this animal?
It was a year in January.
Well, it's been a year in January, she said. Well, she has no documentation to prove that she owns the animal. Could somebody somewhere pop out of nowhere and say, that's my animal. I had a free lease with somebody who gave it to you. I want it back. Yes, that is a potential risk that you take. Could you defend yourself against that? Possibly so. How do you win or lose? Depends on the law of your state. My recommendation is it would be good to get something in writing proving that somebody has given you title to the animal. But if you can't get that proof, you simply know that you're the owner of the animal and you have to proceed accordingly. It's great to have documentation, you know it's yours, but if you don't have documentation, you accept the risk that if the animal ever has to get sold and you really think you have title to sell the animal, but you're not 100% sure, maybe you can't make a warranty of title in that sales document, which is the one thing I would recommend for everybody who buys or sells horses. The seller may disclaim warranties, as I talked about, in a way that's legal in their state, but there's one warranty that every seller must make, and that is a warranty and a promise to you, the buyer, that they own the animal and are legally able to transfer title. So in your case, you don't have that. Can you make that promise to someone else? If you believe reasonably that it's yours, I suppose you could sign a warranty of title. But there's a little question mark there. Best to get it in writing if you can. Next question.
This is a question from Nebraska. Is just hanging a sign stating the Equine Liability Act for your state sufficient, or would you suggest having a waiver as well?
Very good question. Is it enough to simply post a sign that says, we have an equine activity liability law, don't sue us, or a sign that complies with your equine activity liability law, using most of the language that I have in my written materials that are on page 7? My answer to that question is do not rely on a sign to protect you from a claim or a suit against somebody else, and here's why. What I find when I work on liability cases around the country is that the stable that I'm representing may have had signs everywhere with the Equine Liability Act language. Those signs may have been in the entranceway of the facility, in the tack room, in the wash rack, in the grooming area, in the arena. But guess what happens? The person who sues, the injured party, always denies in the litigation I handle having seen the sign. What sign? I don't know what you're talking about. And sometimes they go the distance to say, I know the day that I was hurt, those signs were not posted. Given that reality, and I truly think a lot of these people are lying, but they claim they're telling the truth. Given that reality, my recommendation is don't rely on a sign to protect you from liability, because a sign is enough to show that you have a policy or you're following the law and you're trying to protect yourself from liability. But the one way you can prove that the individual who is entering your premises, riding, driving, or handling your horses agrees to release you is that one document, that release of liability. With that in mind, it's my strong recommendation to all equine activity business people that you use releases of liability, make sure that they're legal in your state, and make sure everybody of legal age at your facility has a release on file. They don't have to sign one every time they come in, unless your document says this is only valid today, but you need to have it on file. And in some states, like in Ohio, you have to revisit it every year if you are a university or a college-related equestrian program. Otherwise, it's my understanding that these releases can live on, and they could be kept on file for an indefinite period of time. Next question, do we have time for a
I
question?
think this will be our last question, and it's from Iowa. If I am sponsoring an equine event, like a riding clinic, do I need liability release or waiver?
Good question. I am sponsoring an event or a riding clinic. Do I need a waiver? Well, I know from experience that people who put on clinics are getting sued. They have been sued. Some of these natural horsemanship people who put on clinics and colt starting clinics have been sued. I also know that I represent one of the big clinicians. I'm not going to tell you his name. He travels all over the country. He's pretty popular. I've received calls from his people, and they say he's going to Iowa, he's going to Virginia, which is a bad state for releases. Can you help draft a document? We'll have it reviewed locally. Releases, I think, are critical for clinics and for activities of that type that take place at any location. However, if you're a Michigan-based business, let's say even an Iowa-based business, and you're traveling to another state for your activity, make sure the document complies with the law of that state. There's another problem. At a lot of these clinics and these events, children are participating. You've already heard the problem of releases, waivers, as they're sometimes called, and children. They sometimes don't quite go together. You'd want the parent to sign for the child if you can do that, but recognize that the document should be signed by everybody of legal age who is on the premises, participating in the event, or having some connection to the event. Make sure it's on file. I'm a strong believer in it. Any other questions, or are we effectively done?
I think we are done with the broadcast
Okay.
because we need to switch over to the next. But Michigan has a little bit of an advantage at this point. And she's not going to disappear off nursery anyway, so.
I'll stick around for the
If you
locals.
wouldn't mind just fielding a few questions while we get set up for the next speaker. that'd be
Okay.
great. Thank you.
Goodbye, Iowa, Nebraska, and Minnesota.